My name is Nathan Hochman. I'm the District Attorney of Los Angeles County. With me up at this podium is Assistant District Attorney Maria Ramirez, Assistant Head Deputy of the Major Crimes Division Habib Balian. We have John McKinney, Director, Gilbert Wright, Assistant District Attorney, and Seth Carmack, a Deputy District Attorney. Also on the Menendez team is Ethan Milius. The purpose of today's press conference is to give you an update on the Menendez case. When we last spoke, I informed you that the Menendez case has been on 3 parallel tracks. The first track was the habeas track. That was a track started with a motion filed in May of 2023, where the Menendez brothers are asking for a new trial based on new evidence. About several weeks ago, we filed our informal response dealing with that habeas petition, opposing the habeas petition, and saying that the justification for the new trial based on 2 additional pieces of evidence did not meet the legal standard to warrant a new trial. The second track that the Menendez case is on is the clemency track. This is a petition that the Menendez brothers filed directly with Governor Gavin Newsom. He could have acted on this petition either now, he could have acted on any moment since he has been in power since 2019. He can act on it today if he so chooses. He has unilateral constitutional power to commute the Menendez's sentences if he chooses and release them today. There is no hearing he needs to have, there is no deadline, and he can also do nothing. The third track is resentencing. And we are here today to discuss that third track. The resentencing is a law that was passed by the state legislature in California, somewhat unique law to California, that basically gives the judge, under certain circumstances, the power to resentence someone who has been previously sentenced. In this example, potentially, the judge could resentence the Menendez brothers from life without the possibility of parole to life with the possibility of parole. Now, resentencing hearings get started in 2 different ways in this case. One of the ways is that the court has initiated these proceedings itself under Penal Code Section 1172.1A1. The second way it also got started is when the prior district attorney filed a motion under this code section to begin the resentencing proceedings. The position we are taking today is that we will go forward. We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal. Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions. Governor Newsom gave us a primer on how this actually works when he dealt with the Sirhan parole recommendation that had been made to him back in 2021. At that point, Sirhan, who was the assassin of Senator Robert F. Kennedy in the Ambassador Hotel back in 1968, had been up for parole hearings 16 times. For the first 15 times, the parole board denied parole. But on this 16th time in 2021, the parole board recommended a grant of parole to Governor Newsom. So he looked at the case and he actually issued a written decision. And in that decision, he analyzed the factors that were both in favor of parole, and there's an analogy to resentencing, and the ones that weren't. The ones that were in favor for parole was that at the time of that parole hearing recommendation, Sirhan was 77 years old. He had been in prison for 54 years. He was suffering from a diminished physical capacity. In his childhood background, he had lived through a war-torn area. He was 24 at the time that he committed those crimes. And while in prison for those 54 years, he had engaged in comprehensive involvement in rehabilitative and self-improvement programs. He earned his Associate of Arts degrees and other certificates. He engaged his classification score, which is an analysis by the California Department of Corrections and Rehabilitation as to what type of risk level you're at, was at the lowest. It was a 19. In fact, the California Static Risk Assessment said it was that lowest level. His rule violation reports, that's the number of reports that he had experienced since he had been in prison since 1968, was 2. And the last one was in 1972. He had letters of support from prison officials, and he had letters of support from 3 of the 9 living Kennedy family members. Yet the governor looked at all those positive factors, recommending parole for Sirhan. Now it's in 2021, 2022. But he said that one factor overcame all those other factors. And that one factor is that Sirhan had not demonstrated full insight into his crimes. He had not completely accepted responsibility for his actions based on his multiple stories of what had occurred that night in 1968. So notwithstanding the fact that he did not, he had all these positive aspects, and he had the parole board recommending a grant of parole, in January 12, 2022, the governor wrote that Sirhan poses an unreasonable risk of danger to the community and denied that parole. The reason this can be an instructive case is that there are almost no cases right now on Penal Code Section 1172.1, the resentencing statute. But the focus of it is the same focus as we have in the parole context. Is there an unreasonable risk of danger to the community by these particular people? In Sirhan, he was a murderer of Senator Robert F. Kennedy, and he shot 5 additional people that night. And here we have the Menendez brothers, who are murderers of their parents the night of August 20th, 1989. While Sirhan is 77 at the time that Governor Newsom made his decision, right now the Menendezes are either 57-year-old for Lyle Menendez or 54-year-old for Erik Menendez. They've served 35 years in prison. Sirhan served 54 years. They don't suffer from the diminished physical capacity that Sirhan does. They had also childhood allegations of physical, sexual, and emotional abuse in their childhood, while Sirhan had never been arrested or charged or convicted of any crimes before his offense. Erik Menendez had been arrested for multiple residential burglaries and received diversion, and Lyle Menendez had also been arrested for multiple residential burglaries. When it comes to rehabilitative programs, yes, both Sirhan engaged over the 54 years in significant programs, as have the Menendezes. When it comes to education that they earned, Sirhan earned an Associate of Arts degree. Erik Menendez has earned multiple Associate of Art degrees and is currently enrolled in UC Irvine. And Lyle Menendez earned his Bachelor of Arts degree from UC Irvine. As far as classification scores, they're all at the same level, a 19, which is considered the lowest level you can be at in the prison system. With respect to that California Static Risk Assessment, they're all at the lowest level. Rules violations, you had 2 for Sirhan, the last one in 1972. You have 9 for Erik Menendez, the last in 2021, and 8 for Lyle Menendez, the last in 2024. They each have letters of support from prison officials, and the Menendezes have multiple letters from all living victim family members aside from one who recently passed. And they received those letters in support of their being released. With respect to them, the key issue of exhibiting insight, full insight into their crimes, and completely accepting responsibility for their actions, this is where the Menendezes, like Sirhan, also fall short. As we lay out in our pleading, which is now 87 pages long, we go through a 60-page statement of facts, which is different, by the way, than the 3 pages that the prior motion had laid out as far as the crimes that are involved. And as we show, the essence of the defense that the Menendezes have maintained from the first trial into the second trial to the present day is that they acted in self-defense. They had an actual fear of imminent harm, in essence, that their parents were going to kill them the night of August 20th, 1989. As we show extensively, and just to make this point, that this case is not, or their defense was not about sexual abuse, because I know that issue has come up many times, but about self-defense. I take you to both Erik, Lyle's, and their own attorneys' statements. At trial, Erik testified, and he was asked, "Did you kill your father because he sexually molested you?" Answer, no. "Did you kill your parents because you hated them?" Certainly no, was the answer. "Did you kill your parents because you wanted their money?" Answer, no. "Did you kill your parents as an act of mercy?" Answer, no. "Why, Mr. Menendez, did you kill your mother and your father?" "Because we were afraid." "What is it you were afraid of?" "I was afraid of dying." "Who were you afraid was going to kill you?" "My mom and my dad." Lyle Menendez similarly testified as well. It was asked the question, on August 20th, 1989, "Did you or your brother kill your mother and father?" "Yes." "Did you kill them for money?" "No." "Did you kill them because you wanted to pay them back for the way they had treated you?" "No." "Why did you kill your parents?" "Because we were afraid." That is the essence of their defense at trial. It was not sexual abuse. The jury was never asked to render a verdict on sexual abuse. It was all about self-defense. In fact, Erik Menendez's attorney, Leslie Abramson, said, "We have never said that because you're abused, you're justified in killing your abuser. We didn't argue that and never will." So the question then is, have the Menendezes exhibited insight into the fact that their self-defense defense was fabricated? And as we go through the iterations of their defense that they issued from the time that they were arrested until the time that they went to trial, until the present day, what you will see is that the self-defense was the last iteration and version of their defenses. Because remember, the first defense that they came out with was, "We didn't do it. That's not us." If you remember the 911 call, if you remember Erik Menendez screaming and crying when the police came out that night, he says to the police, "We're going to kill them," referring to the people who had just murdered his parents. "We're going to kill them. We're going to torture them." Who would have done this thing? The answer is the Menendezes. But their first iteration was it wasn't them. It was either the mafia or the cartel or the dirty business associates of Jose Menendez. They persisted in this lie not just the night of August 20th, but kept that lie going for months and months and months. And had Erik not confessed to his therapist, Dr. Oziel, months later, and that confession been taped, and that confession's tape been turned over to the police, they would have maintained it wasn't us. They convinced not just the media, not just the police, but their family and their friends that they were 100% innocent of these crimes. Until eventually these tapes came out, they were arrested, and then they changed to the next iterations. Because the next iteration of the story was when Lyle Menendez gets his girlfriend, Jamie Pisarek, to visit him at prison and says, "I want you to testify that my father drugged you and violently raped you," establishing that Jose Menendez was a violent rapist. Jamie Pisarek refused to do that. So the next iteration of the story was that Lyle Menendez asked Jamie Pizarnik and said to her, well, Erik Menendez was raped by my father, but I was raped by my mother. That's a story that was then repeated to Erik and Lyle Menendez's uncle, Carlos Baralt, that Erik Menendez was molested by the father, but Lyle Menendez was molested by the mother. That iteration didn't go forward. The next iteration that ultimately came out at trial and just before trial was that both boys were molested by the father. But as you heard a moment ago, that wasn't a defense to the charges of first-degree murder with special circumstances, because you had to add one more thing that the jury was now going to consider, is not just that they were sexually abused, but they were actually in actual fear of imminent harm, of their lives being taken by their parents the night of August 20th, 1989. So self-defense is the defense that they set forward at the trial. But what we show in our pleading is we go through the timeline to show that the Menendezes have basically engaged in not just the ultimate lie of self-defense, but a whole series of lies around it. And they took actions that were both premeditated and deliberate, not just sort of immediate responses to their parents somehow threatening them the night of August 20th. We point out that days before the murders on August 20th and August 18th, the Menendezes drove 120 miles to San Diego to purchase shotguns and ammunition and used a fake ID and a fake San Diego address to make sure that the guns and the ammunition would not be connected to them. The day before the killings, August 19th, they go to a firing range and they find out that the birdshot ammunition that they had bought isn't good enough to kill someone. They're told you need buckshot ammunition in order to actually kill someone, and they buy it that day. Hours before these killings, at roughly 10:20 p.m. on the night of August 20th, Lyle Menendez contacts one of his friends, Perry Berman, to set up the alibi. And the alibi was that they were going to go to Batman the movie at the 8 o'clock showing. And they would be at that movie when the killings would have occurred, and then meet Perry Berman at the Taste of L.A. event afterwards. They set this up before the killings. Now, during these killings, as we've explained before, these weren't just a situation where all of a sudden the parents threatened their lives, they reached for something and shot them dead. No. These killings, the actual shots, were designed to make it look like a mafia gangland hit. They shot Jose Menendez through the back of his head. They shot Kitty Menendez not only once, which then caused her to go down to the ground, bleeding, but when they ran out of ammunition, they went back to the car, reloaded the shotgun. Then Lyle Menendez took the shotgun, put it up to Kitty Menendez's face, and pulled the trigger. Again, to make it look like a gangland shooting, but that was not enough. They then, while they were dead, shot them in the kneecaps to make it to complete the picture of what a gangland shooting would be. And at that point, they also had the presence of mind to pick up all the shotgun shells that were lying in the den, because they were worried their fingerprints might be in them. They then called Perry Berman to establish the alibi and went to the movie theater to buy the tickets, only to find out they couldn't buy the 8 o'clock showing because the next showing had already occurred. And Perry Berman had already moved on to a different event, so they couldn't meet up with him. So they took all those shotgun shells, they took the bloody clothing, they go to a gas station dumpster, and they dump it in the dumpster. But now they got the shotguns, what to do with them? They had the presence of mind to drive up to Mulholland Drive and throw the shotguns off the hill on Mulholland Drive. They then went back to the house. When they get back to the house, that's when they made the 911 call that someone killed our parents. And then when the police arrived, that's when they said, as I said before, when Erik and Lyle are running out screaming and crying, and Erik says, I'm going to kill them, I'm going to torture them. Who would do this? Knowing, of course, that it was him and Lyle who had done that exact crime a little more than about an hour and a half beforehand. So you had a situation then where thereafter they engage in this deception, the mafia hoax, the lies to their friends, their family, the media, and the police. And what's interesting as well is the actions they take immediately afterwards. If these were kids that had just lost their parents, you would think the last thing in their mind would be to check on where the will is. But sure enough, within 48 hours, they go ahead and obtain the computer that they believed a new will had been written on, disinheriting them, bring in a computer expert to delete and then double delete all the files dealing with Erik, Lyle, or Will that are on the computer. Go ahead and remove the safe from the family home into a neighbor's home to look at the safe only to determine there was no will in that. And then even go to the bank safe deposit box to go ahead and see if Jose Menendez had put the new will there, disinheriting his sons as he told them he was going to do. So the story again keeps going on, and today Erik and Lyle Menendez, at least from the beginning, fully expected for them never to go to prison because they had successfully convinced everyone that they didn't do it until they spoke to Dr. Oziel. And Erik, feeling the pangs of guilt, feeling even suicidal, talked to Dr. Oziel and basically told Dr. Oziel that they had done it. When asked about why they killed their father, they didn't mention self-defense. Why they killed their mother that night, they didn't mention self-defense. What they said about the father, what Erik said, is that he was a controlling, dominating force, and that is the reason that he was killed. When he was asked about the mother, he said the mother would be a witness to the crime, so she had to die. That the mother was so miserable because the father had had an affair that we needed to put her out of her misery. That the mother could not live without the father, and if we were going to kill the father, we had to kill the mother. What doesn't happen in any of the taped conversations with Dr. Oziel, and remember, he is being brought on by the attorneys to eventually go ahead and prepare a defense to the murder charge. So what they never tell Dr. Oziel in all the taped confessions is that they were in any fear of their life that their parents were going to kill them that night or any night, and that they experienced sexual abuse by the father. So the story then goes on, because once they get into jail, additional lies come up. I've spoken before about the lies that Lyle tried to tell with Jamie Pizarnik about her being violently raped by Jose Menendez. They also enlist another of Lyle's girlfriends, Tracy Baker, where Lyle literally writes her a script, a letter that is found later, that lays out a story of the mother trying to poison the Menendez brothers and the entire family. Tracy Baker actually testifies to this false story in the first trial, though not in the second. And not only that, but Erik and Lyle Menendez each testify to this fake "mom's going to poison us" story. What we also find out is that Lyle enlists one of Erik's friends, a guy named Brian Eslamania, to go ahead and corroborate the self-defense story. How is he going to do it? Because the letter that Lyle writes to Brian Eslamania, which is actually found by the police, he has detailed instructions down to the actual word that Brian's supposed to say that the day before these killings, the Menendez brothers came to him to get his handgun in order to establish that they had this fear of their parents even at 24 hours before and tried to get a handgun. That is actually disproven. And when it's disproven, again, Brian Eslamania says, look, I didn't have that conversation with the Menendez brothers, and I didn't even have a handgun to give them, even if they said that I did. So you had these situations. The Brian Eslamania attempted suborning perjury. The Jamie Pizarnik attempted suborning a perjury, and the Tracy Baker actual suborning a perjury. that the Menendez brothers engaged in to establish the self-defense. But it failed. And the reason we know it failed is that a jury heard all this evidence. And the jury, the second jury, the first jury hung. But the second jury that heard all this evidence rejected the self-defense and found them guilty of first-degree murder for both parents with special circumstances. And what's also important to note is that this conviction has been run by 5 different courts over the last 30 years. It went to the California Court of Appeals. It went to the California Supreme Court twice. It then went to the U.S. District Court. It then went to the U.S. Ninth Circuit Court of Appeals. The Menendezes have brought up every single argument that they bring up now about the faulty jury instructions, the exclusion of certain sexual abuse evidence at the trial, about certain other court rulings, and it's been rejected and rejected and rejected over and over and over again. So, in looking at then whether or not the Menendezes have exhibited the full insight and complete responsibility for their crimes, they have not. Because, and we outline this in 20 different lies that they have told, which is an attachment to our submission. They have told 20 different lies. They've actually admitted to 4 of them, but 16 lies remain unacknowledged. They persist in these lies to this very day. So like with Sirhan not being able to exhibit full insight into his actions, so too have the Menendez brothers failed to exhibit full insight into their actions. Let me give you 4 examples where they've actually admitted to the lie. Erik and Lyle lied on the 911 call about just discovering their parents' bodies. Again, when they were found out and the tapes came in, they admitted to that lie, and I mean the lie of the 911 call. The second lie that they've admitted to is that they lied to the police, family, and friends and the media about their involvement in the murders. Again, when their confession came out on tape, they had to admit to that in the first and the second trial. They admitted that they lied to the police, family, and friends, suggesting the mafia was involved in the murders. And Erik admitted that he lied when he told his expert psychiatrist, Dr. Vickery, that his parents would kill him because his father's homosexual lover warned him that he was in danger 2 days before the murders. This is something that Erik Menendez told Dr. Vickery, and then months and months later finally recanted and told Dr. Vickery that that was a lie. But there are 16 lies that remain to this day that have been affirmed as recently as last year, where they affirmed the self-defense and they've never admitted to the suborning of perjury of others or the attempted suborning perjury. These lies include when Erik and Lyle claimed that their parents were going to kill them, that they had to act in self-defense by murdering them first. That the Brian S. Lamina letter, that they basically tried to suborn perjury from Brian S. Lamina, telling him to testify that they borrowed one of his handguns the night before the murder. Another lie that they told to support their self-defense story is that on that Friday, when they go down to San Diego, they said they actually didn't start in San Diego. They said they started at the Big 5 sporting goods store in Santa Monica to try and buy handguns. That unfortunately there was a 14-day waiting period, they said, so they couldn't buy the handguns at that Big 5 sporting goods store in Santa Monica. They both testified to this. Turns out, as the evidence came in at trial, the Big 5 sporting goods store in Santa Monica hadn't sold handguns for 3 years at that point. So it was impossible for them to have actually gone and tried to purchase a handgun instead of a shotgun that particular day. They've never admitted that they provided that fake ID and fictitious address to buy those shotguns in San Diego in order to conceal their connections to the shotguns and the ammunition. They just said that they used a fake ID because they had driven all the way down to San Diego and forgot their California driver's licenses. They testified that the day before the murders, they had stayed away from the home all day that Saturday, even though a witness came forward who was the pool repairman, who said they were playing tennis that day at the house and disrespecting the parents who were in front of them. Again, another lie which they have never acknowledged. They lied when they said they didn't plan that alibi before the murders. They lied when they said they did not ask Perry Berman to come back to their house in order to be a witness on the discovery of the mutilated bodies. They lied when they said that they did not stage the murders to look like a mafia gangland hit. They lied when Lyle said that he tried to suborn that perjury from Jamie Pisarcik about his father drugging and violently raping her. They've never admitted that they lied when they testified that their mother was so dangerous and unpredictable that she tried to poison the whole family. And they've never admitted the suborning of perjury from Tracy Baker when they actually got one of Lyle's girlfriends to testify to the fake mother's poisoning the family story at trial. They further lied when they testified that they thought their parents were going to kill them during their Saturday afternoon fishing trip. They lied when they testified that when they burst into the den with their shotguns, that it was too dark to see and their parents were standing up or moving towards them. Expert testimony showed that at all times the parents were seated on the couch when they were shot, or mom was on the ground bleeding to death when Lyle came back and shot her in the face. They lied when they said that they testified that the reason they rushed in on their parents was because of self-defense, and they thought that their parents were going to shoot them first that evening. And they lied when they testified that Dr. Oziel blackmailed them into confessing on tape to murdering their parents. We lay out this series of 16 of the 20 lies that they have never acknowledged, never showed insight into, never completely accepted responsibility for. By the way, what I just described to you was mentioned in a paragraph in the original motion that was filed by the district attorney's office. There was no discussion of exhibiting insight into one's actions or completely accepting responsibility for it in the original motion. So we are basically, in some ways, offering a path to the Menendez brothers. And here's what the pathway looks like. If the Menendez brothers at some point, unequivocally, sincerely, and fully accept complete responsibility for all their criminal actions, acknowledge that the self-defense defense was phony, and their parents weren't going to kill them the night of August 20th when they murdered them in cold blood. Acknowledge that they suborned or attempted to suborn perjury in all the various ways I have outlaid. If they go ahead and finally come clean with the court, with the public, with the DA's office, with their own family members, and acknowledge all these lies, and then can be said to have fully and completely accepted responsibility for their actions. In the future, the court can weigh these new insights into making a determination as to whether they now qualify for rehabilitation and resentencing. And the people will do the same. The district attorney's office, if it is presented with these new insights, unequivocal, sincere acknowledgments of all the lies they have told for the past over 30 years, we too, in the district attorney's office, will reconsider whether or not we would want to go forward with a resentencing motion. But for now, while the Menendez brothers persist in telling these lies for the last over 30 years about their self-defense defense, and persist in insisting that they did not suborn any perjury or attempt to suborn perjury, then they do not meet the standards for resentencing. They do not meet the standards for rehabilitation. They have not exhibited the full insights and accepted complete responsibility for their actions. And as a result, just like in the Sirhan case, they pose an unreasonable risk of danger to the community, and the resentencing should not, therefore, be granted. I'm going to stop now. I'll take any questions that anyone has. After I'm done with these questions, Maria Ramirez will address the Spanish-speaking media and provide information at that point.
The hearings on March 20th and 21st, there's word that they have been postponed. Is that the case?
So those hearings, whether they occur on March 20th or 21st or at some point later, first it's up to the court on what the court ultimately wants to do. The court is receiving our response today. We anticipate the court may keep the March 20th and 21st dates to deal with our response. Again, part of our response is to go forward with the court's initiated motion for resentencing, and part of our response is a request to withdraw the DA's motion in this regard. The court might have the hearing then on that issue, and then if in fact it decides to go forward with the full resentencing, set a hearing in the future. I know that the governor has now ordered the parole board to do the risk assessment. That risk assessment can take up to 90 days. We don't know when it will actually be completed. The court may or may not want to have that risk assessment done before it has the final resentencing hearing.
Yeah, can you just clarify? So obviously you've laid out this case. This reply motion will be in the file no matter what, but you cannot pull back Gascon's motion. You're asking the court to pull that away. If they decline in this hearing, the court will then have to weigh both motions equally. How does this play out in that?
Effectively, yes. So what will happen is, again, you have, in some ways, double motions going forward. And in looking at the different motions, we have now analyzed the original motion filed by the district attorney's office and saw that in no way, shape, or form did they deal with what we believe to be one of the key issues, this exhibition of full insight and complete responsibility for one's crimes. So we are pulling back or asking the court to withdraw that motion, while we're also indicating to the court that we're prepared to go forward on the court's own motion for resentencing.
Considering all the facts that you brought up, do you think there's any chance the Menendez brothers are going to get out of jail in the next few years?
Again, we have laid out a pathway for the Menendez brothers to potentially get out of jail. It requires them to finally, after 30-plus years, fully acknowledge and completely accept responsibility for the entire breadth of the crimes and all the lies that they have told, including their defense at trial of self-defense. If they go ahead and do that, and they do it unequivocally, and they do it sincerely, ultimately the judge is the final arbiter of the sincerity and whether or not this is just being done to please someone, or whether or not the Menendezes have fully come to grip with the lies that they have told. Again, they had no problem at trial coming to grips with the fact that they had lied for over 6 months to the police, the media, their family, and their friends about the fact that they never did it, were not involved at all, and it was the mafia that had actually done the hit on their parents. So they have a history of acknowledging some lies. I'm hoping that they continue with this evolution of themselves, their improvement of themselves, to finally come to grips with the acknowledgement of the totality of their crimes and their lies. And at that point, the court may very well entertain the idea that they have met all the criteria to not only be rehabilitated, not only no longer pose a danger to society, but to be resentenced.
But you don't think they're getting out of jail until they do that?
Our position is that they shouldn't get out of jail. Now, ultimately, that is a position. We bring that position to the court. The court can agree with it, the court can disagree with it, or modify it in some respect. I'm sure that the Menendez's lawyers will be arguing that the court should go forward now with the resentencing. I've spoken to the Menendez family members. And by the way, I spoke to the Menendez family members who support the Menendez brothers before I spoke to Milton Anderson, who recently passed. I spoke to him after I spoke to the Menendez family members, and they certainly would like him out, or them out, tomorrow. And they'll be encouraging the judge to do the resentencing now. But as we have looked through the facts and the law, and that's what's governing our opinion. It's not emotion, it's the facts and the law. They have failed to meet these requirements to show that they are no longer an unreasonable risk of danger to the community, and that is why our position is that resentencing, if it occurs, they shouldn't actually be resentenced.
Sir,
Have you called the family by any chance and notified them of your decision today?
We have not actually spoken directly to the family today. We filed this at the earliest possible time we could at 8:30. We're having this press conference at 10. But when I spoke to the family before, it was an over 3-hour meeting with the family members, the over 20 family members that support the Menendezes being released. And we talked about their rehabilitation in prison. We talked about their beliefs of what happened at the time of the crime. We had a very wide-ranging conversation, and I sat there and I listened to it all. But it does not eliminate the fact that in order to show a full and complete acceptance of responsibility and show full insights into one's criminal actions, that as we have laid out in detail, the self-defense defense was a fabrication. They need to admit to that. They need to admit that they suborned or attempted to suborn all the perjury. And at that point, we might be in a position, if they do it sincerely and unequivocally, to be in a position to then go back to the court and recommend resentencing. Right here.
What if they do that in the next couple of weeks before the resentencing hearing? They acknowledge everything, and would you find that to be sincere? Would that change your
Given that
opinion?
you've talked about all the lies they've said, how would anything that they would tell you, how would you deem that to be sincere after you've gone through this whole litany of lies that you claim they've made?
I will address that in the same way that people ultimately were able to believe the Menendezes when they admitted to the first several lies, the first 4 lies. Because remember, at that point, you had a situation where the Menendez brothers said, we didn't do it. The mafia did it. But they took the stand repeatedly at trial and said under oath that no, we lied when we said we didn't do it. We lied when we said the mafia is the one who gunned down our parents. And they were able to, again, express under oath that belief, and they did it over and over and over again. So if the Menendezes go ahead and want to, at any point, whether it's today, whether it's weeks from now, months from now, or years from now, finally and unequivocally express that they and acknowledge the lies that they have told and persisted in for over 30 years, then we will certainly evaluate the quality of that sincerity and decide whether or not it's real or fake, whether or not it's just designed to get out of jail, or whether or not they truly believe and acknowledge the full breadth of the crimes and lies they have told in deciding what to do at that point. And as importantly, the court will have to make that decision, and that decision is the court and the courts alone to make.
Yeah, the family filed a Marcy's Law complaint. I'm sure you've seen this with a wildly different characterization of the meeting than you've offered in the past. They are actually claiming we were hostile towards them, that they were looking at bias and asking for the case. I don't know if there's any, obviously offers different characterization of that meeting. Do you dispute that, the description that they made?
So it was a 3-hour meeting. And remember, the district attorney is not obligated to meet with any of the family members, not even obligated to necessarily, certainly not obligated to meet in person. I could have taken written communications from any of the family members and actually did receive some written communications. But I sat there for over 3 hours. I didn't tell any of the Menendez family members what to say or what I wanted them to say. I said, whatever you want to say to me, please say it. And I sat there and listened to everyone who wanted to speak to me until they were done speaking. So if they've characterized that meeting in whatever way they're going to characterize it, so be it. I understand that the Menendez family members want, the ones that are supporting this, want the Menendezes out today. They could go to the governor if they wanted to actually achieve that, literally go to the Governor Newsom today, and he could commute their sentences and release them today. I, on the other hand, am bound by the facts and the law as it pertains to an analysis of whether or not resentencing is appropriate. And that is what I've done. You know, again, the jury heard this self-defense defense way back when, and the jury rejected it. We're just basically, in many ways, following the jury's verdict from way back then, while the Menendezes have for over 30 years not only rejected the jury's verdict, but persisted in the lie of self-defense and the related lies I've talked about. In the back, yes.
Still go through with this while it's in the governor's hands. Some could say it makes no sense.
Why go through the resentencing? That's actually up to the court. The court can decide to continue a hearing and wait for the governor to weigh in. The court can keep the hearing on March 20th and 21st. District attorney is not going to tell the court what to do in this respect. Yes, over here.
What about the issue of the age they were when they committed these crimes and how laws have changed with regard to likely out the possibility of parole?
Good point. Sirhan was 24 years old, and the law says that youthful offenders are under the age of 26. If you actually look at the governor's decision dealing with Sirhan, he mentioned that he has to give special consideration to the age of a particular person, particularly if they're under 26, that the law requires. And so, too, for resentencing, should the court give such consideration to the age of the offender. Sirhan was 24, Lyle Menendez was 21, Erik Menendez was 18 when they committed their murders. So yes, we need to give that consideration to the age of the offender. And I use the example of Sirhan, where that consideration was given, but yet the failure to exhibit full insight into one's actions and completely accept responsibility for the breadth of one's crimes overcame the pro-parole factors that the governor considered.
Going back to what the family had claimed in their letter to the U.S. Attorney's Office, beyond how they framed the meeting, they say in an ongoing way you are biased against the Menendez brothers. How do you respond to those things?
I am not. As I've said, not only am I not biased, but I will follow the facts and the law wherever they take us. And in fact, so much so that I've explained in quite long detail exactly where the lack of insight into their criminal actions occurs. I've outlined 16 different lies, 20 lies total, 4 of which they've acknowledged, 16 of which they have not. So I've outlined a pathway in the district attorney's position on how the Menendezes could exhibit these new insights. Now, whether they're sincere, whether they're unequivocal, that's between the Menendezes and mostly the court as to whether or not the court actually believes them. But if that were to occur, then I've said the district attorney's office, if it believed that these new insights were sincere and unequivocal, then we would reconsider whether or not we would go forward on a resentencing motion.
You referenced your new filing is 60 pages, and the filing from the previous DA's office was just 3 pages.
What I meant to reference, if I wasn't clear, is our statement of facts dealing with the crime was 60 pages. The statement of facts dealing with the crime in the original motion was 3. And if you look through, I'm sorry?
Do you think that was incomplete? Do you think they did a poor job or poor framing?
I think it was incomplete because they never undertook the key analysis of whether or not the Menendez brothers have exhibited this full insight into the breadth of their criminal actions or completely accepted responsibility for all of them. As a result, we spent, and also the original pleading focused mostly on the probation report, statements made in the probation report. We went to the trial. If you actually look at our 60 pages, there are references to trial transcripts. There are references to court appellate opinions that analyze the facts. We didn't rely on a probation report where a probation officer is summarizing testimony, where that testimony is not under penalty of perjury and not subject to cross-examination. We went back to the source materials. Now, what was involved in that? It was a review of most of 50,000 pages of trial transcripts from 2 months-long trial, thousands of pages of prison records, hundreds of hours of videotaped testimony. We also spoke to prior prosecutors, defense counsel, the Menendez family members, as I mentioned, and law enforcement. So we did as best over the last several months a full debrief and download on the Menendez case to arrive at the position that we've arrived at today. I'll take one more question right here.
Who would they have to tell that they accept or take responsibility for those lies or actions? Who would they have to express it to?
They can do it in any form. Ultimately, it has to be to the court, because the court will be the arbiter and the judge of whether or not the Menendez brothers have finally exhibited full insight into their crimes and completely accepted responsibility for them. So, however the Menendez brothers want to convey that sincerity and that unequivocal admission that they have lied to everyone for the past 30 years on their key defense of self-defense, suborning perjury, and attempting to suborn perjury, I will leave to the Menendez brothers and their counsel.
It has to be during a hearing.
It can be in any form. They can do it with declarations. They could do it with videotaped testimony. They could do it at the actual hearing itself. I'm not going to in any way suggest how they do it. They have a very qualified counsel who can advise them how to do it. It's up to them, though, on whether or not they want to do it. All right, I'm gonna stop right now. I will turn it over to Maria Ramirez for any one-on-one interviews. They'll be in the green room. And thank you very, very much for being here today.
If they get out, what does that say about the current system that the government could override it?